I'm Marcelo Rodriguez. I am the Foreign Comparative and International Law Librarian, as well as Professor of Legal Research here at the College of Law. And it's really my great pleasure to be here today, helping my colleagues in the library, especially Library Director Teresa Miguel Stearns, who really created this faculty book event and that faculty book talk, which I think is a fantastic opportunity to engage in intellectual conversations with speakers, not only from our faculty, but also the external speakers like we're going to have here today. I'm just going to introduce them very briefly, and then we're going to jump into the conversation, okay? And also for the people on Zoom, I'm also logged in, so in case there's any questions, just let me know, okay? Daniel B. Rodriguez is a Harold Washington Professor of Law and also served as Dean of the Northwestern Pritzker School of Law. His principal academic work is in the areas of administrative law, local government law, statutory interpretation, federal and state constitutional law, and the law business technology interface. And we will be talking to our colleague Jordan Woods, who is the interim dean for academic affairs and professor of law here at the University of Arizona College of Law, where he writes and teaches courses in the areas of criminal law and procedure, law and sexuality, family law, legal ethics, and he's also the co-director of the Family and Juvenile Law Certificate Program. Take it away.
Great. Thank you so much for the introduction. Thank you all for coming. Thank you for Professor Rodriguez for coming here and talking to us about the wonderful book. Hopefully those of you who are online can see the book here, Good Governing the Police Power in the American States. So the book, it's an incredibly rich analysis, rich in history, rich in discussions of how the content and topic about the police power intersects with modern questions that are relevant for today. But as a starting point, to give the audience some background, maybe you can tell us a little bit just about the main focus and topic of the book to get us started. That would be great.
So I'm happy to. Let me begin with an apology, then a thanks, and then get right to your question. The apology is I'm getting over a bit of a head cold, and although I'm not at all contagious, anyone who's been through that will know it's like being a feeling of being underwater. So if my voice is too loud or too quiet, apologies. Let's try to kind of work my way through it. The thanks go to Teresa, who I think is here on Zoom, and Mark Miller, who I know is in LA, and Jordan and Marcelo, and all of you. I know it's an incredibly busy time of the semester, always busy, but this is especially a busy time. And to squeeze me in, it's a great delight. I'm an outsider, but an insider as well. As Chris knows, I'm sort of like a bad penny. I don't go away. We have a residence here in Tucson, and so we spend a good chunk of time when most people spend time in Tucson, here in Tucson. So I'm always glad to be able to come to the law school as a peripatetic visitor. Okay, with that in mind, so I think I remember the question. The book is title is not self-explanatory. The part over the colon gets, of course, to the topic at hand, which is the police power, and that is, in short, the power to regulate health, safety, and welfare. Sometimes it's seen as the general welfare, the common good. Often morals is put in there, so maybe health, safety, morals, and the general welfare. It's power that is given to state governments in the original iteration to state legislatures. Although, as I talk about in the book and as others have observed over time, of course, state government comes to include local governments, the executive branch, special purpose governments. Maybe we can talk about that to some extent. And it finds its origins in the state constitutions. And indeed, there's some interesting backstory that's not prominent in my book, but that others have written about, that sort of goes back to Blackstone, policia, the police idea of the government's important, almost parens patriae role in regulating for the benefit of its citizenry. So I undertook to do this book to really give a deep dive into kind of the conceptual foundations of the police power. It's not a work of legal history. I'm not a legal historian, but there's certainly some chapters that situate the police power in the founding of the American Republic and goes through the development, origins of police power in our constitutional framework, as it continues through the next 2 centuries and up to the present. It's also a book of, so it's about the concept of the police power in that respect. It's a sort of conceptual dive. It has historical pieces in sort of trying to help us figure out how we got from there to here. It has an important, what I hope is some important structural lessons about how the police power is configured and how it goes beyond just this notion of the legislature sort of blessing regulatory power by acting a certain way, but it has various structural components to it that are embedded in long-standing struggles over the content of local government and the relationship between state and local governments, the relationship between state legislatures and state agencies, and all of that. And last but not least, particularly in the last 2 chapters, it gets at what I would say is a little bit more of a polemical section, more advocacy, and that is how governments in modern times, especially at the state and local level, ought to use what is sometimes an underutilized police power in order to tackle the sorts of wicked problems that states, certainly the federal government as well, but states face, like affordable housing, issues involving the environment, transportation, gun safety and gun regulation, wealth inequality, and other public health emergencies, and the like.
Great. Maybe you could tell us a little bit about the title, especially the good governing part, and what you're hoping to get across.
So, at the risk of being too clever, and of course, when you try to be clever, it's like a joke. You don't want to then explain the joke, kind of, and I do that in the book. So maybe I should have not given up while I was ahead. But the idea of good governing is good governing in a twin sense. It is governing for the public good. So a big focal point is, say, the police power is about health, safety, and welfare. We can sort of come to understand what health might mean, what safety might mean, but what is the common good? What is the general welfare? And the way in which, just to get a little ahead of ourselves maybe, the way in which the police power morphed, particularly in its first 100 or so years, from what, let me throw a little Latin at you, a sic utere conception, a notion that the police power is really about the use of public law methods to solve common law, private law problems. So, adding to nuisance law being a classic example. We teach about property, right? The law of nuisance being elemental as part of the private rights that individual property owners have. You may use your property in any way you want, as long as it doesn't interfere with the rights of others. Local regulation that limits the use of property is a public law analog to nuisance law. And so the police power was understood for many years in its early years as, well, it's basically that. It morphed into much more of, or evolved, I should say, into much more of a salus populi notion, that the police power would really be utilized to promote the common good. So the first part of good governing is governing in the direction of the common good. The second element, the twin element, is really the polemical part that I mentioned, the normative part, which is we impose an obligation on our representatives, on our government officials, to be effective at governing. And we might well believe, as doctrinalists, in a law school setting, well, it's not the business of the courts to interfere and decide whether a particular regulation was a good one or a bad one, whether it had a means and fit, whether it was Pareto optimal or things like that. That's well beyond the scope of what courts ought to do. And I generally believe that's the case. But nonetheless, we impose an obligation on courts in dealing with disputes over regulatory power, and also on the public actors themselves, like the legislatures and agencies, a responsibility to be effective at governing. So it's good governing in that, in that dual sense.
So some of this you touched on a little bit, but police power is such a massive topic. There's so many different ways that you can approach it. What are some of the main messages that you're hoping that, or at least that you set out to explore in the book, given how big the scope, police power really is?
Sure. But before I dive into that question, if you'll permit me just a tiny little tangent. No one writes about the police power anymore. I throw down the gauntlet to anybody who teaches federal constitutional law or has a colleague that teaches federal constitutional law and say, how much time do you spend on the police power? They might say none at all, or they might try to twist it around and say, oh, well, in the free speech part of the class, I talk about the ways in which free speech limits the scope of the police power. Well, then it's not about the police power, it's about doctrinal free speech. So, and there's not, law reviews are not chock filled with the latest articles about the police power. So it's by and large, a bit of a scholarly dead letter with conspicuous exceptions. 100+ years ago, it was a very different story. There were no less than 3 major constitutional treatises just on the police power. One was by a guy named Thomas Cooley, you may have heard of. Another was somebody, Christopher Tiedemann, who you probably haven't heard of, but he took it upon himself to write an 800-page plus treatise on the police power. And last but not least was Ernst Freund, the great, almost like Zealot. He was a legal scholar that was the founder of the municipal home rule movement. In some ways, one of the founding fathers of administrative law. He wrote a book about this thick called The Police Power. So it used to be all the rage, and it sort of died out. All right, so some key things. One I've already mentioned, and I guess I would reinforce it, and that is a point about the evolution of the police power from a more narrow common law sourced conception of government regulatory power to a view of government power as not infinitely elastic, but enormously ambitious, and ambitious in order to implement important public aims surrounding health, especially, and safety, and the like, and manifest in broad regulations that had significant impacts, no two ways about it, on individuals' liberty interests, and also on how individuals use their property. There wasn't not a big bang moment. It didn't happen in one particular case. There were some, as Jordan knows from looking at some of the chapters, at least one of the chapters in the book, there were some very odd doctrinal detours, like the Lochner era, right, which was not primarily about the police power at all, but about limits on state and federal power under the liberty of contract and all of that. But by and large, the notion that the police power was a broad, ambitious power that would carry out public aims became well established by the turn of the 20th century and only increased over time. And by the way, it increased irrespective of what we all know is the classic story about the growth in federal regulatory power, a point I try to make in the book. So rather than see the police power at the state level as growing and growing and growing, and then along comes the progressive era in the late 19th century and the New Deal and the civil rights movement and all of that, and then state power is narrowed in order to make room for broad national power. That is a vast oversimplification. In fact, federal power expands, not under the police power. Federal government doesn't have a police power, but it expands under the commerce power, under Section 5 of the 14th Amendment, under all that rubric. But meanwhile, state power expands as well. So that's a key story I tell. Another, but in some ways that story has already been told. And there's a really, really important book. I hope that I give it its due throughout my book, written by William Novak, who is a trained legal historian, unlike present company, who wrote a book many, many years ago called The People's Welfare, which is really about the police power, and really makes the case from a strong historical perspective that it evolved into a power that was about the people's welfare. Excuse me. But there are a couple things that Novak leaves out. And the one that I want to mention here is he leaves out in important respects, as have others who've written about this, that despite the growth in regulatory power under the police power, think of a case like Jacobson versus Massachusetts that got a lot of headlines during COVID. That was a case in 1905 in which the Supreme Court upheld the use of mandatory vaccine in the state of Massachusetts on the grounds that this promoted public safety, and there were no constitutional barriers, even individual liberty, that stood in the way. So we certainly saw the expansion of the police power, but it came also with important limits. The most famous limits, and that are well known to all of us, are federal constitutional limits that came about as rights jurisprudence sort of exploded on the scene in the mid part of the 20th century and beyond. So First Amendment, equal protection, due process, all of the fundamental rights and the ways in which they restricted various state police power. The story that's not, though, told, I think, and I hope this is a contribution, is that the state courts also built up and built in internal legal constraints on the exercise of the police power. Let me actually take a step back and broaden that. State governments imposed internal limits. So state governments created a body of state administrative law that would deal with the exercise of regulatory power by state agencies. And a lot of the federal administrative law that we've become quite familiar with over time, it grew out of those efforts at state. They created a distribution of powers so as to give the governors some ability to exercise police powers. As you recall, they did actively during the period, the COVID period, but they imposed limits. They created non-delegation doctrine state law. So various limits were baked in order to circumscribe what might be a limitless use of the police power. But back to courts. The courts also developed doctrine. And they developed doctrines in the form of, they sometimes call them reasonableness limits, so that there's an obligation imposed on state and local governments who would exercise police powers to be reasonable in doing so. There are some areas of law in which that didn't factor as too serious a constraint, like in zoning, but in other areas in which it did. They looked at issues of animus to see whether or not the use of the police power was mostly a product of choices motivated by animus. That became a big deal in morals regulation context. So another key theme of the book that is part of really sort of part two in what's three parts is the way in which, despite the awesome scope of the police power, which is sort of the if you just read the first three chapters, kind of the lesson you take from that first part was, wow, there's a lot there. That internal limits were seen as necessary in some important respects. So that some of the broad themes. In addition, again, to the ways in which in the last section I try to tee up, as it were, some issues involving the use of police power in these kind of big subject matter areas.
So one of the more powerful parts of the book, to me, is in the framing, sort of press this, just the lack of scholarly conversation around the police power. And I imagine that was partially a motivation for what got you excited about this work, but maybe you could touch on a little bit more, what motivated you to write this work? Why now?
Sure. Not so much the dearth of scholarship about it. It wasn't like I was looking around for something that hardly anybody had written about. That in some ways that's kind of dangerous, because you do that, you're sort of saying, well, maybe there's a perfectly good reason that people didn't cut their teeth on writing about the police power for all this years. So, but I would say the motivations came from two very different areas. One motivation was, this is as much about the trajectory of my own career, so it's kind of autobiographical as much as anything else, although focused on the research. It wasn't like I had a dream that came to me to write about the police power. It was that I've spent a number of years in my scholarship writing about state constitutions and state constitutional law. I like to say, before it was fashionable as it is these days, crying in the wilderness. But writing about and teaching about the structure of state constitutions and some unique features, not only unique among different states, but unique in state constitutions as compared to the national constitution. So when I teach in my state constitutional law classes at the various schools I taught this at, which is now a large number, because I can't hold down a job, I start out almost at the very first class by saying, here's a central difference between the US Constitution and state constitutions. The national constitution is a document of grant. That of course the devil's in the details in terms of how doctrine has emerged, but the federal government has only those powers delegated to it by the Constitution through we the people. State constitutions are documents of limit. So they have these broad powers that are exercised, almost intrinsic powers, innate powers, except insofar as they're limited by the scope of the Constitution. So that's a puzzle. And the police power, if you think about it, makes it even more puzzling. Because if the police power is taken seriously, is that just an instantiation of the notion that state governments can do whatever they want? I've, a number of talks I've given about this even prior to the book. A lot of the questions or comments preceding, this is more of a comment than it is a question. And sometimes the comment that I would get is, what I'm hearing you say is basically the police power is the power of the government to regulate in any way it wants, except that there's a right that stands in the way that limits the scope of that. And after a while, I thought to myself, rather than push back hard, I'm not doing, I needed to write a book that tried to put in real context why that's actually not accurate. The police power is not just a general words that express the notion that the government can do whatever it wants. So thinking about my writing about state constitutions, thinking about regulatory power and regulation, something I've been interested in. Police power seemed like a really interesting fulcrum. So that's the big one. The second is COVID, which is to say, during the COVID pandemic, I was teaching courses, actually a fair number. I taught one on Coursera, I taught an open access course, I taught it for our law students for a couple of years, then it all went away. But I taught a number of instantiations. That meant I took a really deep dive into COVID cases that were being litigated, particularly public law COVID cases. And there's contracts, out the wazoo, most of which, of course, became moot. But a lot of the public law cases, as you'll recall, involve disputes over the police power in this state and other states. The governor doesn't have the authority to impose lockdowns. Where does that come from? If it's just in the name of public health, you have to do better than just simply mouth the words public health. The argument was often made. Mask mandates, gathering requirements. A lot of these cases were being litigated the police power, and courts were deciding them often very quickly, without anything approaching any perspective on or theoretical apparatus that would help guide them in thinking about the scope of the police power. So that too became a sort of a motivation. I mean, at one point I was like, well, to write a book about police power during COVID. Well, maybe, but all that would really do is illustrate how interesting the police power is more broadly. The COVID restrictions being an example of its use or its misuse, but only an illustration among many other illustrations, be it zoning, morals regulation, adult theaters, which directly comes out of the exercise of the police power in some of these cases. So it was out of teaching the COVID cases that was another kind of motivation to think about this.
So one of the positive things about this book is that there's so much that lawyers, law scholars, law students, people outside of law could get from reading it. What are some of the lessons that you hope that folks take away from it, whether it's from the historical analysis or the normative analysis?
The first chapter of the book, right out of after the introduction, is almost nothing about the police power as such, but it's about state constitutions. And it's helping to sort of situate how state constitutions should be thought about in their construction and their origins and their mission. Again, not a work of history, but a work of kind of the conceptual underpinnings of state constitutions. And then, of course, in much of the rest of part one and throughout the book, tying the police power as a concept, as a principle, as a set of doctrines to state constitutions and how we think about state constitution. So one measure of success to me would be whether folks agree or disagree on the doctrinal exegesis about the police power, some of the normative conclusions, or how I view, some doctrine, some stuff that's been written about by a lot of folks over a long period of time, like the Lochner era, regulatory takings, things like that, some of which get, frankly, in this book, a little bit more drive-by treatment than serious sustained treatment. But I'd like folks to think about, state constitutions have a lot of generative potential to help us think through constitutional analysis. And I think that's happening a lot. I think there's a renaissance of interest in state constitutions, state constitutionalism. There's some really brilliant, talented folks, almost all of whom are younger than me. I don't even know why I put almost in that. And God bless them, because they're really thinking about state constitutions from some really important vantage points. So I hope that is an important takeaway. And to get to the other end of the book, the introduction, the kind of analysis over the scope of some key subject matters is something I hope that we'll take from it. Let me give you one concrete example. This is actually, it's not treated in any great detail in the book, but maybe I'll write this article, maybe somebody else will write it, but I think it might be interesting. I mentioned gun regulation before. Now, we all know that story the last, decade and a half. Okay, gun regulation, now it's an individual right under the Second Amendment. It's sort of put on steroids, as it were, in some recent cases. Most important of which probably is Bruin, says original public meaning of what gun ownership and all meant in the time of the framing. I know I've oversimplified it, but there's a sense in which, and there's a lot written about, did Raheny take some of that back, and what's the focal point of Bruin? a conversation I've been having with this law professor at Fordham named Saul Cornell, who, unlike me, spent years and decades researching the Second Amendment and he's thought about this, but he likes this argument, so I'll mention it here, is even if you take seriously Bruin on its own terms, as, yeah, you got, really take a deep look at the original public meaning of the Second Amendment of what gun ownership meant. Doesn't that also oblige the same originalist judge to take an equally significant look at what the framers also thought about the scope of government regulation? In the original public meaning of the scope of regulation, turns out there's a lot of regulation at the time in the name of public welfare and safety, a lot of new technologies, including guns. So the reason here's how it ties back to Jordan's question is I'd like folks to look at some of the problems that they're really interested in. So I don't know much about this other stuff, but I know a lot about zoning and affordable housing, and maybe draw a lesson as now he tells us, meaning me, something that the police power might illuminate with respect to that. Give another quick example. Some of you have heard the Grants Pass decision that was decided by the Supreme Court, a year and a half ago, in which the Supreme Court rejected the argument that certain homelessness prohibitions and bans on camping that are really directed toward the homeless population in Oregon violated the Eighth Amendment, and sort of put to end the notion that cruel and unusual punishment is a vehicle. I think it pretty much put it to the end, that is a vehicle to strike down homelessness regulations. And there was a lot of hand-wringing about that. I didn't actually think the decision was wrong myself, but I understood the hand-wringing. Part of the hand-wringing is, what do we do now? Are we just left in a world in which homelessness bans are free from governmental constraints because we can't figure another anchor in the US Constitution? Well, of course, there might be anchors in the state constitutions under the rubric of how the police power has been read to impose a reasonableness requirement. So when I'm sitting there listening to Justice Gorsuch ask some of these questions to the bench, to the lawyers, saying, isn't there something else that we might look at? Is there like due process, something like that? And taking that seriously, it could be that a close look at the police power and how we read the police power may be a doctrinal opening for reconsideration of homelessness. So I'd like to think that last chapter could spirit up a lot of analyses. The test is not whether I agree with them or disagree with them, or whether I write them or somebody else writes them, or whether they give homage to me writing about the police power or not. It just generates that kind of interest even among students, maybe especially among students. I think mission accomplished. They're the ones who are going to go out, lawyer these cases, and not to mention maybe write about them or things like that.
So we're still doing good on time, and I promise that we're going to leave at least 15 minutes for Q&A for the audience. But one question that I'll transition to is the research and the writing process. That's always exciting to hear from the author firsthand what this was like. So maybe you just illumine us, what was the process like? Anything that you encountered that you found was especially surprising, unexpected?
Sure. So I thought about doing this, we all have our eccentricities, and I have probably more than my share. One eccentricity is I in undertaking a big project like a book, maybe this also is true for some of the articles I've written. I tend to take a Ulysses strapped to the mast strategy, which is I went out to see if I could seek and acquire a contract for the book, with just to propose it, being ready to say, hey, not ready for prime time, come back to us when you have something more substantial. My ego could take that. But Cambridge was encouraging and said, great, like what you're saying here, and go for it. And this was in 2000, I think, 21 or that particular period of time. And so said, great. And it began really the research part of this in earnest at that time with the kind of and that's why I say it's somewhat eccentric, because would I have been equally motivated if I just thought I'm going to write this book and see whether the world wants it? Who knows? But I thought, no, I have a deadline, I have an editor, I've got all these. So I really spent a lot of time researching it. The way I tend to work is I'm a slow researcher and a fast writer. So I knew that pouring a lot of time into reading and just all sorts of stuff and just really deepening my knowledge and understanding of what turns out to be, you will confirm this having read the book, a wide variety of topics, right? Yeah, in a good way. Took a lot of time for research. when it came time to writing, and I was hoping this would come up here, and I'm glad it is, about 90% of the writing was done in Tucson, Arizona. When I had the luxury, which I do not take for granted, of having a very favorable arrangement with my law school after giving the law school the best years of my life, Steve, I took maximum advantage of that with respect to a lot of time for writing away in the spring. So I have wonderful memories of going for long walks and hiking and doing the sorts of things you do in Tucson, Southern Arizona in the spring, while really bringing to sort of the close a lot of the research and doing a lot of writing over that particular period of time. I know this is not directly relevant, but you may be interested in this anecdote. A weird thing happened on the way to getting this book published. So I slipped a bit with respect to the deadline, but was reasonably pleased as they were getting it done. Big accomplishment. Was able to do a kind of a pre-publication book conference. Everything's on track to have the book published in its final form last summer, middle of the summer. So kind of June comes and goes, July comes and goes. I don't want to be a pest. Figure they'll let me know, So I kind of, but after a while, I'm thinking, something up. So I kind of write. Let a week go by, nothing. Write another, kind of, hey, what's up? I think I've done the proofing, done the indexing, done all the, checked all the boxes, anything left to do. Then I start getting notes back, bouncing back, like this person does not work here. We've never heard of this. Then I'm thinking, there's being ghosted and there's being ghosted. It's like they shut down Cambridge Press lest they have to communicate with Dan Rodriguez about his book. I mean, the level of paranoia was getting hot. It turns out when they finally got back to me at the end of the summer, this being past the deadline for publication, they wrote back very apologetically saying Cambridge Press, a big press, an old press, hit with a cyber attack, a massive cyber attack that had wiped out their system, kicked people off, took away their email messages. I verified, I looked on the site, they said, you've been hit by a massive cyber attack. We cannot publish any books now. We don't know when we'll be back open for business. You just have to wait patiently until we get our systems in place, and then the order in which their publication. I mean, that's like, go away, we'll tell you when we reopen. And I was, of course, took that as good nature as you want. I did have my moments. At one point, I sort of said to myself, if a cyber attack hit the University of Arizona, God forbid, probably has happened, or Northwestern, it'd be really bad, right? Could major disruption of the system. They probably wouldn't shut down the university for a semester. I would think that'd have to be a pretty bad cyber attack. But Cambridge just basically said, can't do what we can't do. So didn't hear anything back. Then I'm just curious, just as my own self-obsession. I'm thinking, well, this is kind of weird too, because by the way, on Amazon, you could already tell when the book was kind of pre-order, and so I don't know how many pre-orders. I have a lot of relatives, so I guess decent. So people had pre-ordered it and sort of said nothing. So then I wanted to just check the status pre-order. So one day I'm sitting at a conference, actually an ALI meeting. I look at it and it says, news, Daniel Rodriguez, Good Governing, to be published 2 weeks from now. So it got back on track. And what do you think I did? Shut my big mouth. Didn't say a word. Just basically let the 2 weeks go by. And on that moment, the book got published. So it was a freaky experience in terms of the entire genesis of that.
Yeah, I don't want to think about a cyber attack hitting Arizona. My job would be
I couldn't
much more difficult.
Yeah, it would be. I didn't have a lot of negotiating, especially since I was desperate to have it come out. So like, there's no acknowledgments page because I don't think they had time to. So I looked like kind of an a-hole because I didn't dedicate it to anybody. The other thing I didn't get to do is I had the idea in mind. I'm sure they were rejected on this last page of a picture of me sitting there on my outside, because of course it's Tucson in March. There's a road runner in front of me. You can see off in the distance. There's the mountains of Tucson. There's my dog. May he rest in peace. He passed away before he could see the publication. Good guy. On my lap. I'm thinking, and my computer. I'm like, that should go in the last, but alas, that was not to be.
Okay, so we're good on time. Let's open it up for audience questions, and Marcelo's kind of help with the online questions as we get those, since everyone is behind us. But any questions, actually?
So thanks, this was very interesting, and I had question about the internal limits. So I like how you set it up like there's external limits from constitutional rights, and that makes sense. And then you name, and I haven't read the book yet, but I'm looking forward to it. At least 2 internal limits, it seemed like. So, as you're characterizing them, so like reasonableness and animus. Is that?
I think in the book I characterize. I say the kind of the heading is reasonableness, but how courts actually reveal what they might think of as unreasonable regulations is you see that in examples of animus. You see that in examples of self-dealing or self-interest. And I'm going to tell you right now because I've forgotten. Self-dealing, animus, arbitrariness. Okay. So the playbook, of course, is familiar to legions of folks. So you can say, oh, that's like Cleburne Living Center. And I mentioned Cleburne Living Center in there. And animus, oh, that's shades of that in Lawrence versus Texas and Romans forever. So I try to bring it back to federal constitutional cases that you might think about. But these are manifest in a lot of state cases that no one's heard of.
Yeah, okay, great. No, that's very helpful. And I guess I was wondering, so it seems to me like, one way you could approach Commerce Clause being essentially limitless would be to try to develop internal limits on it.
Right.
And there are some, obviously, the court has developed, but this would be another way to do it. And I guess I was wondering, or if you want to develop internal limits for consecutive power. Like what are the sources that they're drawing on to construct these reasonableness limits? Is it just like a common law, sort of like intuition? Is it past cases? Like how do they identify what violates the reasonableness requirement?
So I don't want to overclaim. And when you're doing kind of a look at, this is not unique to police power writing, but if you're looking at 30, 40, 50 cases, to draw one overarching theme would be impossible. It's hard enough to do when you're reading Supreme Court decision. So I don't want to say there's one through line that goes throughout them. But what I think the strongest message that comes out of these cases, and the message that I reinforce in that chapter of the book, is they emanate directly out of the police power itself. So the internal limits are internal to the police power. So when it says the power to regulate health, safety, and welfare, this is, you can imagine what that means is, and not just imagine it like dream it up, but think about this in terms, if you're with me in what I've said earlier in the book, is that it was never meant to be limitless. It was always understood to exist alongside liberty and property rights, but that's about rights, but also about self-contained limits on the ability of the government to regulate in any way it wants. Now, if I had, in some ways, I'm disappointed. It's what's done is done. In some ways, I'm disappointed with myself because one of the messages that folks draw who have read that chapter is, and this is on me, is more enthusiasm than I really intended for a robust use of these internal limits to limit the scope of the police power. They ask, understandably, didn't we learn our lesson in the Lochner era and in other places that, when you start looking at reasonableness as a standard for, subjecting it to governmental power, you have no sort of rights, that you're not going to be able to go anywhere with that. And maybe Wilson versus Lee Optical overshot by basically saying rational basis all the way through. But don't we see that should be the exception rather than the rule? Why aren't you more enthusiastic about structural limits? And what I wanted to say is, I'm not that enthusiastic, but then they're like, oh, but then so if I had a redo on that, I would say something like 2 cheers. And in fact, there's a subsection that says 2 cheers, but that's in the eye of the beholder. How strong, how loud is 2 cheers? Is that the reasonableness limits, to the extent they emanate from the internal structure, are always going to be squishy for just that reason. And we should be understandably careful, as we are in federal constitutional law, to see the courts as imposing a general reasonableness review over agency action.
Then flipping to the external limitations.
Yes.
And here, if we think about either primarily or exclusively as federal constitutional limits,
or state constitutional rights.
or state constitutional rights, where there's a conflict between the use of the police power and a right delineated in those constitutions. I think we can easily, especially from the COVID period, think about things like First Amendment rights in the US Constitution or analogs in the states, religious congregations and the like, right? I don't know why it was peaked while I was listening to you talk, but have we seen in this century and decade any arguments, and I know there's controversy around dormant commerce clause arguments, but does that ever arise where a state uses what it thinks is within the scope of its police power, but there is a negative effect on interstate commerce? For example, like if you had a very strict jurisdiction around COVID protections and it eliminated all sorts of professional sports or concerts, things like that. Has that arisen at all?
Well, sure. I still think it's the most recent Commerce Clause case decided by the Supreme Court was a case in an animal welfare case that involved California that imposed significant restrictions on the size of pens for animals, and then required, I may get the facts a little off, it's not my area, but required then that other states who purchased meat, bacon, and all that have those same limits. And the question was whether it was a dormant commerce clause. Now, dormant commerce clause is doctrine all the way down. So the way in which it was decided gave short shrift, to put it mildly, on the state's rationale under the police power and whether the police power pushed that. They basically, but to your point, is they definitely use that as something that might be perfectly congruent with state police power, their issue in general welfare.
Within the scope of what most people would think of as a reasonable use of the.
Yeah. I mean, as a thought experiment, if the dormant commerce clause was not a significant limit, if the doctrine was not there to do it, could there have been some litigation on the question of, and I've had this debate with one of my colleagues who teaches animal rights, is on the theory that, well, you go through the list of health, safety, and welfare, there's nothing in there about animals. I had the same reaction you just had, which is, well, but animal welfare, you can do whatever you want, but show me where health, safety, and welfare means the welfare of animals. And if you do say it's the welfare of animals, you got some big problems on your hands because all the mice that are killed every day, by my next door neighbors at Northwestern Hospital. So maybe there's some internal limits that would make those restrictions reasonable or unreasonable. And I talk about some of the culture war kind of issues in the book. And I say, just lest you think, there's wild examples that are going on, at least I find them wild as we speak. Like, can the state of Missouri use the police power to prohibit reading children's books to kids in bookstores wearing drag?
Right.
There's a law in the books, not to mention the drag show legislation. So people read that section and say, damn, conservatives are always legislating stuff. San Francisco bans shark fin soup. There's cities around, again, California, other places that ban foie gras and things like that. So local governments are using the police power to, the mask requirements.
Yeah.
And like the situation in Arizona that flipped that around, which is like statewide prohibitions on local governments. You guys face that, stuff like that.
Yeah.
So I'm not sure that's a satisfactory answer to your question, but yeah, I think it comes up where there's some federal limits. There is a chapter in the book that is meant to be limited in its scope, and it has the caveat it's limited in its scope. I still get folks that say you gave it too short shrift, which is a federalism section. So I try to say this is not a book that illuminates much about federalism. I get that the question of federalism looms large in any questions of state regulatory power, totally. But we can understand and should understand the state police power as a state power within its structure without it necessarily thinking that it's driven by federal constitutional limits and federal constitutional rules. By the way, one other, can I say this, or I don't want to do it? One other quick point that I mentioned: external limits are individual rights limits in various ways. But the courts have, in certain doctrinal areas, in my opinion, mangled a lot of the doctrine in ways that they might not have mangled it as heavily if they had taken seriously the consideration of police power regulation. Regulatory takings, I could talk all afternoon about that, but won't. But another area is in the adult entertainment cases. So the adult entertainment cases are interesting because the court had a way of seeing these cases through by saying what the state is doing is regulating secondary effects, which is quintessentially police power. But instead, they eroded that and put in its place, no, the state is doing so in order to promote public morals because they don't like folks dancing without pasties and things like that. Once you put it into the morals basket rather than public safety, you change the dimensions of what might be a reasonable or unreasonable police power restriction. And even though that happens at the Supreme Court level where they're fiddling around with what the First Amendment means or doesn't mean, or, you know, all these different ones. Again, that's an example, I think, where federal constitutional jurisprudence, and I think that's true of regulatory takings, might have benefited by a more nuanced understanding of why the state regulates private property, why it regulates, you know, to stop with the problems of blight and, you know, all those kinds of issues.
You touched on this briefly when you're talking about grant paths.
Yeah.
How are state police powers used rather than regulating, but in ensuring certain rights that are not in conflict with federal rights?
So interesting. If I understand your question, so they bolster the right. Then I think the answer is yes. That happens. Police power becomes the regulation that is carried out into the police power becomes an important mechanism for safeguarding individual rights and the scope of those rights. So I think you see that in property regulation and property rights laws in different ways. Now, some of that may be even more salient in the state constitutional context, because you probably already know this, but state constitutions have what are so-called positive rights. So, you know, that's partly where the kind of the much maligned and Mount Laurel litigation that, you know, I learned in law school back in the Stone Ages, where the New Jersey was really looking to enforce individual rights sort of housing, and doing so by imposing restrictions on the way in which Mount Laurel was dealing with these issues. And that was, most folks think that was a failed experiment, but we're back to that now, given the crises of affordable housing. And if you believed, I'm not as moved by that as some, but if you believe there's a fundamental right to housing that should be protected, it's a constitutional right worth protecting in the state context, then to your point, you could think two things that are interesting. One is that state regulations and regulatory laws that are intended to promote affordable housing, protect affordable housing, and advance it should be given special solicitude. And how we think about reasonableness in that context is one. The second, and in some ways maybe even more interesting element of that is, and I touch on this a little bit in the book, is there are certainly good arguments that the exercise of the police power for zoning regulations is at odds with affordable housing. And there's a lot written about that. As you know, economists have been writing about that. Many folks have been making, Carol Rose, Bob Ellickson, a lot of, prominent legal scholars. So just think about that. If you can imagine more than 100 years after Euclid, looking at zoning regulations and saying, some of these zoning regulations, although they purport to be, in the public interest, they actually have deleterious effects on affordable housing. So say it the economists and political scientists. Can they still be reasonable under principles of police power? Aren't they in fact acting in certain ways that is at cross purpose with affordable housing? Now that's a heroic view of lawyering, that a court would be convinced and strike them down for that reason. But you accumulate facts, you have the modern iterations of Brandeis briefs, you find a sympathetic judge, then that could be another way in which the police power serves the agenda, to your point, of advancing constitutional rights that are not in conflict with federal with federal interests, but would promote the interests of state citizens, and also provide for some experimentation, which is another message I think in this book too. And anybody writing on state constitutions, which is you have 50 of them, not to mention the territories. You have some room for some ingenuity thinking about these. You're gonna ask me about my next book?
That's my last one. My
Okay.
closing
That's
question is
very
very.
relevant.
I'm gonna do us one commercial.
Huge book, what's next? That's where this is taking you.
I got the same, fragile ego, Ulysses strategy this way. So I also got a contract. And you know who I got a contract with? Cambridge Press. There were a couple others, but the editor was almost surprised. I thought we had like a lifetime Dan Rodriguez ban on. I said, well, make sure your computer systems are solid on this. It's a book that grows out of a course I've taught a number of times at Northwestern called Regulation Along the Frontier. And it's basically how we think about regulatory strategies and modalities of regulation on things that are frontier problems. Obviously, new technology problem, AI, cryptocurrency being, kind of modal examples of that. Now, it's not a book that says, here's how we're going to regulate AI. I'm not, I have some humility, but it is one that says, here's some first principles and second principles that systems, not limited to the United States, should think about in tackling new technology. So my subject matters are AI, cryptocurrency, climate change, little tiny issues that no one's written about, public health emergencies, sort of the COVID issue, and drugs in a kind of dual sense, the opioid epidemic and how we think about regulating that, and also cannabis, which is not a new technology, but it's been thrust into our modern attention because of the legalization movement. But a lot of folks are, in my experience, are saying, what do we do now? How do we think about mechanisms of regulation? So it's how we think about regulation of those new frontier technologies. So also will be open access, so credibly low price of free, and hoping to get that done with at least 80% of the writing.
So beautiful.
Beautiful too. I'm gonna write as long as I'm what do you call it, above ground, and I'm able to do this. I'm gonna make sure that people understand. I'm gonna write all my books in 2 seconds.
Great, so we can give.
Really appreciate that.
Oh, of course, man. Thank you so much. And please, I know lunch was a little bit late, so please.
Yeah,
wrap up
absolutely.
as
Somebody
we
do in the back.
Wrap up.
Yeah. Thank you so much for coming.
Thanks, absolutely. That's great.
Goes by quick.
Yeah. You guys